appearance to defendant?
Yes, my lord. My name is Moses Ologu. Moses Ologu. I appear for the defendant, counterclaimant. Most grateful, my lord.
In reading the judgment, I shall simply read the introduction and then I'll go straight to the decision portion.
As a court pleases.
As the court pleases.
Counsel can hear me.
Yes, my lord.
Yes, my lord.
As the court pleases.
Judgment. The claimant filed this complaint against the defendant on October 15, 2015, together with the accompanying originating process, and is seeking the following reliefs. 1, a declaration that the meting out of different punishments on the claimant by the defendant, particularly the claimant's suspension, forced resignation from the defendant's employment, as well as detention at the Economic and Financial Crimes Commission's Lagos office is wrongful, illegal, and malicious. 2, a declaration that the forced resignation of the claimant's appointment from the defendant company is wrongful and unlawful. 3, a declaration that the claimant is entitled to the sum of 4,090,487 naira 89 kobo, being the claimant's entitlement for the period of his suspension up till his first resignation from the post of an assistant manager of the defendant's company. Particulars as follows. A, outstanding salaries from March to May 2014 in the sum of 908,152 naira 89 kobo. B, quarterly payment in the sum of 300,187 naira 50 kobo. C, outstanding pension, which was deducted but not remitted in the sum of 123,635 naira 79 kobo. D, productivity for 2013 in the sum of 1,200,000 naira. E, productivity for 2014 in the sum of 500,000 naira. F, outstanding of 108 days monetized in the sum of 1,511 naira 71 kobo. 4, an order that the claimant is entitled to 15% annual interest on the judgment sum of 4,091,487 naira 89 kobo from the date of the claimant's first resignation till the date when judgment is entered in this suit. 5, an order that the claimant is entitled to interest on the judgment sum at the prevailing bank rate from judgment till the judgment sum is fully liquidated. 6, special damages in the sum of 66,226,000 naira, being entitlement for premature disengagement of the claimant from work till retirement age, that is 60 years. 7, cost of this action in the sum of 2 million naira only. The defendant had appearance on 26 February 2016 and filed an amended statement of defense and counterclaim on 28 June 2019. The defendant counterclaimed as follows. 1, the sum of 7,386,457 naira 68 kobo, being the loss suffered by the defendant due to the negligence of the claimant and his ineptitude, unprofessional conduct, ineffectiveness, and incompetence whilst creating the transaction said to belong to and carried out on behalf of Shande Ako Zungwe. 2, interest on the said sum of 7,386,000 457 naira 68 kobo at 21% per annum, effective from the 17th day of July 2013 until the said sum is fully liquidated. 3, the sum of 1,500,000 being recoverable legal fees expended by the defendant's counterclaimant in defending the suit. 4, aggravated damages against the claimant's defendant to counterclaim in the sum of 20 million naira. I will go straight to the decision portion. I have carefully considered the processes filed, the oral and documentary evidence, written submissions, and the authorities cited. The kernel of the claimant's complaint is that the defendant meted out different punishments on him on an allegation of negligence in the following manner: query, appearance before the disciplinary committee, redeployment and demotion, suspension, reports to the Economic and Financial Crimes Commission, a forced resignation, and short payment of terminal benefits. It is the law that whoever desires the courts to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove those facts exist. Section 1311 and 2 of the Evidence Act. Also see the case of Calabar Cooperative Limited versus ECHO. The law is settled that in the determination of employment rights, it is the employee who complains that his employment contract has been breached, that has the ability to place before the court the terms and conditions of his employment that provides for his rights and obligations. Sioko versus Police Council, Okomo Oil Palm Company versus the Serene, Idoni Boyobe versus NNPC. The parties have placed before the court the following documents: the letter of confirmation of appointment, Exhibit C1, claimant's letter of employment, Exhibit D1, query on YC documents and response, Exhibit C2, queries on persistent late coming, Exhibit D3, D4, letter of employment, Exhibit C3, suspension letter, Exhibit C4 and D8, claimant's letter of appeal, Exhibit D9, advice to resign, Exhibit C5 and D11, letter of resignation, Exhibit C4A and D10, acceptance of resignation, Exhibit C7 and D12, invitation to disciplinary committee, Exhibit C15, executive summary of disciplinary sittings, Exhibit D76, human resources policy, Exhibit C22, judgment of the Federal High Court, Exhibit D77, and several other documents relating to the Shande Ako Zungwe transaction. The issues that arise for determination are as follows. 1, whether or not the suit is an abuse of the judicial process. 2, whether the claimant was coerced into resigning his employment with the defendant. 3, whether on the basis and evidence the claimant ought to be entitled to the relief he is seeking. 4, whether the defendant's counterclaimant has proved the counterclaim. The defendant has submitted that the claimant abused the process of court when he filed this case and is pursuing a similar relief as the one he had filed at the Federal High Court, which was dismissed on 1st March 2017 in the judgment delivered. The defendant, in paragraph 61 and 62 of its amended statement of defense, avers as follows. 61. Further, or in the alternative, and in specific response to paragraphs 11, 12, 14, 15, 16, 19, and 20 And relief one of the statement of facts, the defendant avers that the claim herein is an abuse of court process. 62. Further to the above, the said claim which is for the enforcement of the claimant's fundamental rights was dismissed with substantial force by the Federal High Court, Lagos, suit number FHC/L/PS/1566/2015 between Muyiwa Ogunlana versus EFCC and Nigerian Stockbrokers Limited on 1st March 2017. The said judgment dated 1st March 2017 shall be relied upon at the trial. The defendant did not place before the courts the originating process in the Federal High Court. Rather, was placed before the court the judgment of the Federal High Court in suit number FHC/L/CS/06/2017 versus Nigerian Stockbrokers Limited and Economic and Financial Crimes Commission, delivered on 1st March 2017, Exhibit D77. A careful look at the suit number in paragraph 52 shows that it is different from that of the judgment, Exhibit D77. The relief sought by the claimants and reproduced in the judgment are as follows. 1, a declaration that the second respondent detention of the applicant for 11 days without being charged to court is wrongful, illegal, and malicious, as same is an infringement of the applicant's rights to dignity of human person and rights to personal liberty. 2, a declaration that the applicant is entitled to damages for infringement of his rights to dignity of human person and rights to personal. 3, an order of perpetual injunction restraining the second respondent, whether by themselves, agents, servants, privileged, or any other person acting or purporting to act on the first respondent's instructions or otherwise, from arresting, detaining, harassing, intimidating, or molesting the applicants. 4, an order of perpetual injunction restraining the first respondent from using the second respondent or any other person or agency by whatever name so called to intimidate, harass, detain, or molest the applicant. 5, an order of perpetual injunction restraining second and third respondents from invading the home of the applicant. 6, special and punitive damage in the sum of 100 million naira for the illegal and unlawful detention of the applicant. 7, for such orders as the Honorable Court may deem fit to make in the circumstances of this case. The relief sought by the claimant in this instance have been reproduced in paragraph 1 above. However, for ease of reference, I will reproduce the main reliefs. 1, a declaration that the meting out of different punishment on the claimant by the defendant, particularly the claimant's suspension, forced resignation from the defendant's employment, as well as detention at the Economic and Financial Crimes Commission's office of Lagos office is wrongful, illegal, and malicious. 2, a declaration that the forced resignation of the claimant's appointment from the defendant company is wrongful and unlawful. A declaration that the claimant is entitled to the sum of 4,091,487 naira 89 kobo, being the claimant's entitlement for the period of his suspension up till its forced resignation from the post of an assistant manager of the defendant company, particulars as follows. Now, I find that the parties in the two suits are not the same. Neither are the reliefs the claimant is seeking. The Economic and Financial Crimes Commission is the second defendant in the suit instituted by the claimant in the Federal High Court for the enforcement of his fundamental rights. While this instance suit is an employment matter in which the claimant is challenging his disengagement and payment of terminal benefits. The abuse of the process of court may lie in both proper and improper use of the judicial process in litigation. But the employment of judicial process is only generally as an abuse when a party improperly uses the issue of judicial process to the irritation and annoyance of his opponents and the efficient and effective administration of justice. This will arise in instituting a multiplicity of actions on the same subject matter against the same opponent on the same issues. See Okoro versus Okoro Madu, also see Saraki versus Kotoye. The claimant has not done this. I hold that this suit is not an abuse of the judicial process. There is no dispute between the parties that the claimant played a major significant role in the Shande Akpo Zungwe transaction. By his own admission, he and Mr. Teslim Sadiq were primarily in charge of the operations department at the material time, and he issued the account opening package. From the evidence adduced, the entire transaction turned out to be a scam, as the said Shande Akpo Zungwe was an impostor, together with accomplices who are now on trial for capital market fraud. The defendant's managing director queried the claimant on 10th October 2013 on this transaction. His response to the query was unsatisfactory, as clearly seen by the managing director's minutes on his response. The claimant was thereafter invited to appear before the disciplinary committee on 9th January 2014, and he was redeployed on 13th January 2014, pending the conclusion of the ongoing investigation of your activities and your colleague in stockbroking operations. End of quotation. There's no evidence that the claimant's redeployment to enable investigation was a demotion. The defendant's human resource policy, as Exhibit C22 at page 4 states, and I quote, NSL reserves the right to deploy an employee to any other position or location in NSL. I find that the claimant was redeployed at this time to enable unimpeded investigation into the transaction. The executive summary of the disciplinary sittings dated 4th February 2014 is before the courts. The committee concluded that the claimants and Mr. Teslim Sadiq demonstrated incompetence and ineffectiveness, usurped the board's authority by the issuance of indemnities without authorization of the managing director or any other director, and exposed the defendants to liability in the sum of 7,386,457 naira 68 kobo. The recommendation, or rather the conclusion of the committee is that both staff should bear the consequence of the losses and appropriate disciplinary action be taken against them. The claimant was placed on indefinite suspension without pay, with effect from 5th of March 2014 until the conclusion, and I quote, of the ongoing investigation. There is no provision for the suspension of an employee in the defendant's human resource policy, that in the defendant's human resource policy document that regulates the employment relationship between the parties. And this is a contractual relationship. I find that the suspension from duty of the claimant without pay was not in accordance with the claimant's employment contract. The cases referred to by Learned Defense Counsel are in opposite and were decided before the third alteration to the 1999 Constitution. This court is by Section 254C1 of the Constitution of the Federal Republic of Nigeria empowered to apply international best practices. In so doing, the court will not shut its eyes to the provisions of the employment contract and the human resource policies of the defendant company. I declare that the punishment of suspension without pay meted out on the claimants by the defendant is wrongful. The defendants, in line with industry practices, reported the matter to the Nigerian Stock Exchange, who also reported the matter to the EFCC for investigation. I find that the EFCC, in the process of carrying out its statutory duties of investigation of financial crimes, detained the claimant. His detention, therefore, cannot be attributed to the defendants, as alleged. The claimant has in his pleadings alleged that the composition of the disciplinary committee was at the whims of the managing director, and that it offends the principle of natural justice, as the report is bound to be biased. Now, the executive summary of the disciplinary sittings, dated 4th February 2014, is not the report of the disciplinary committee, as stated, and it also does not state who the members of the disciplinary committee are. It simply, as stated, is an executive summary. Under cross-examination, DW told the court that the managing director, the compliance officer, the external consultant, and himself were the members of the disciplinary committee. One of the twin principles of natural justice is nemo judex in causa sua, that a person should not be a judge in his own cause. It was therefore improper for the managing director, who the evidence reveals had signed off on the transaction, to issue the query to the claimant, minute his dissatisfaction on the claimant's response, and thereafter sit as a member, stroke chairman of the disciplinary committee. The presence and membership of the managing director on the committee is a feature in its constitution and composition that represents bias. It was also improper for the compliance manager, whom the claimant had named in his response to the query as being the officer to ascertain the status of a client's KYC, to also be a member of the disciplinary committee. I find that there is a justifiable basis for the claimants to plead bias and denial of fair hearing guaranteed him by Section 36 of the 1999 Constitution by the disciplinary committee. Consequently, the conclusions reached by the disciplinary committee in its executive summary are doubtful and cannot be relied upon by this court. The claimant has complained that the defendant forced him to resign his employment. The defendant admits that it issued the claimant with a letter advising him to resign. The letter is reproduced as follows. 28 May 2014, dear Mr. Ogunlano, advised to resign. We refer to the terms contained in your offer of employment letter dated 14 August 2006, and hereby inform you that your services are no longer required by the company. Consequently, you are hereby advised to resign your appointment from the company with effect from 30th May 2014. Otherwise, your appointment will be terminated. You are to hand over all company's properties in your possession to the head of operations. Upon receipt of your resignation letter, the benefits accruing to you, if any, shall be made available to you within 7 days from the receipt of your resignation letter. Be advised accordingly. Yours sincerely for Nigerian Stockbrokers Limited, Aziz Lawal. This letter speaks for itself. The claimant complied with the advice and wrote his letter of resignation of appointment on 30th May 2014. The claimant's appointment had already been expressly terminated by the words, and I quote, "Your services are no longer required by the company." The defendants again went on to threaten him by the following words, and I quote, "You are hereby advised to resign your appointment from the company with effect from 30th May 2014. Otherwise, your appointment will be terminated." The defendant has admitted in its pleadings and evidence that it advised the claimants to resign. The law is settled that parties are bound by their pleadings and facts admitted need not be proved. See Section 125 of the Evidence Act. See the case of Jolashun versus Napoleon Bangoye. There can be no doubt that the claimant's resignation was not a voluntary one. A voluntary resignation is understood only in terms of the employee taking the decision to resign unhindered by the employer. I find that the claimant was intimidated and forced to put in his letter of resignation, having been threatened with termination of his employment and its attendant consequences should he refuse. This is a clear case of constructive dismissal, and I so hold. Learned Defense Counsel has submitted that the claimant did not plead the term constructive dismissal. The claimant's averments and the defendant's admission amounts to a clear case of constructive dismissal. The defendant's conduct is unacceptable in the world of work. To intimidate and coerce the claimant, as the defendant has done in this instance, is to humiliate, traumatize, and cause him further injury. The position of the law is that a forced or compulsory resignation by an employee amounts to a constructive dismissal associated with misconduct. See the case of CBN versus Aripo. See Patrick Amechi Mbanefo versus EcoBank Nigeria Limited. I declare that the forced resignation of the claimant from the defendant company is a constructive dismissal and it is wrongful. The claimant has made a claim for his outstanding salaries from March to May 2014 while he was on suspension. I have already found that the claimant's suspension without pay is wrongful and does not form part of the employment contract. The claimant remained an employee of the defendant until he was constructively dismissed on 30th of May 2014. He is therefore entitled to his salaries for the months of March, April, May 2014. The defendant is ordered to pay the claimant his outstanding salaries for these months, deduct his pension contribution, and remit to his pension account. The defendant is also ordered to remit its own counterpart contribution to the claimant's pension account. The claimant is seeking a declaration that he is entitled to the sum of 4,090,487 naira 89 kobo as entitlement for the period of his suspension up till his first resignation. The burden of proof in establishing declaratory reliefs to the satisfaction of the courts is heavy, in the sense that such declaratory reliefs are not granted, even on admission of the defendant, where the claimant fails to establish his entitlement to the declaration by his own evidence. See Dumes versus Nwakoba, also see International Operations Nigeria Limited versus Q Oil and Gas Services. Furthermore, this head of claim, number 3, is in the realm of special damages that must be particularized in the pleadings and strictly proved. See Luke Onyora versus Benedict Onyora, see also Emirates Airline versus Ngonadi. There are no particulars in the pleadings, and the claimant has not proved his entitlement to this sum. The claimant has also made a claim for special damages in the sum of 66,226,000 as his entitlement for premature disengagement. There is no proof that he is entitled to remain in the defendant's employment till he attains retirement age. The items of the special damages claimed have not been particularized in the pleadings and are unknown, unproved, and therefore will not be granted. See the case of Anyanwu and others versus Uzuwaka. The claimant has failed to prove his entitlement to special damages and to the head of claim 3 and 6. They fail and they are refused. Consequently, the ancillary reliefs 4 and 5 must also fail. I note that the claimant did not make a claim for general damages for forced resignation. Having not made a claim for general damages, the court cannot award general damages to him for that wrong. On the whole, the claimant's case on wrongful suspension and forced resignation succeeds. Costs of 500,000 naira awarded the claimant on this suit. On the counterclaim, there is no evidence in proof of the loss of 7,386,457 naira 68 kobo by the defendant's counterclaimant. It is the duty of the defendant's counterclaimant to provide the court with evidence to support its claims and its case. See Idigbe versus Ndiche, also see Olufeagba versus Abdul Rahim. Consequently, the counterclaim fails. It is hereby dismissed. Cost of 500,000 naira awarded the claimant / defendant to the counterclaim. For all the reasons given above, I hereby declare an order as follows. 1, I declare that the punishment of suspension without pay meted out on the claimant by the defendant is wrongful. 2, I declare that the forced resignation / constructive dismissal of the claimant from the defendant is wrongful. 3, the defendant's counterclaimant is ordered to pay the claimant his outstanding salaries for the months of March, April, May 2014, and remit the pension contributions into his pension account. 4, costs in the sum of 1 million naira to be paid to the claimant's defendant on the counterclaim. Judgment is entered accordingly.
Well, my lord, we thank the court very sincerely for the industry and wisdom, and we pray that these characteristics continue to abide by the court. Thank you very much, my lord.
Yes, the court will rise.